CBS News has learned the Justice Department has opened an investigation into the collapse of Silicon Valley Bank last week. SVB's failure was the second largest bank collapse in U.S. history and the largest since the global financial crisis in 2008. The bank was the 16th largest in the nation with $210 billion in assets. The investigation in itself is not unusual. What is unusual is how swiftly it has started. Even at the height of the 2008 economic meltdown, it took weeks before the Fed started looking at the collapse of the major firms. Jonathan Macey joins me now for more. He's the Sam Harris Professor of Corporate Law, Corporate Finance, and Securities Law at Yale University. Jonathan, let's start with this Department of Justice probe. What could they be looking into? And if you wouldn't mind, can you identify what was dumb but legal in this case, and then what might possibly be illegal?
Sure. So what was sort of has bad optics is that some senior executives in the bank sold stock shortly before the bank failure. And this looks kind of sketchy, but there are specific provisions in the securities laws that allow directors and officers of public corporations to sell stock and make securities trades pursuant to pre-existing trading plans. And apparently that's what those executives did in this case, in which case, absent any additional information, while it looks really bad, it's probably legal.
If that's the case, even though these might have been planned trades for, scheduled a long time ago, is that money nevertheless possible to be clawed back in the current environment that we're in now that the bank has collapsed?
It's possible, but as long as these directors were acting pursuant to the these so-called 10b1 trading plans, then I think it's unlikely it will be clawed back. The question is whether they had any material inside information when these plans were formulated.
Right, because the suspicion is they knew things were going south and they got their money out before they did. But because it was a planned trade, they would have had to know it much earlier in advance. And that's what would be at issue. Let me ask you about the assurances they gave to depositors with the bank when they said everything's fine just hours before it collapsed. Could that put anybody in difficulty?
Well, that is much more problematic in my view. But to the extent that they know or should have known that there were significant liquidity problems and runs on banks, it's a tough situation because what brought this bank down was a bank run, all the depositors panicking and wanting to get their money out in an expeditious fashion, which of course nowadays you can effectuate deposits electronically on your phone and the like. So they were probably acting in what they thought was the best interest of the institution by trying to quell the panic and calm everybody down and stem all of these withdrawals, which were putting so much pressure on the bank's balance sheet.
It was reported that KPMG gave the Silicon Valley Bank a clean bill of health 14 days before the collapse. It also gave one to a Signature Bank, which has also gone down 11 days before. Does that help the defense at Silicon Valley Bank? In other words, our accountants said everything was fine. So if they said it was fine, how could we know?
I don't think that helps them. It's a great fact. It's an amazing fact that both for Silicon Bank and Signature Bank, they got clean bills of health from KPMG, 2 weeks in the case of Silicon Bank and 10 days in the case of Signature. But those, technically the audit periods for those sign-offs was slightly different than the period for the financial collapse. So the dates don't exactly match up from a kind of technical point of view, if you know what I mean.
Yes, I think I do. Let me ask you one quick question about Dodd-Frank. That legislation, which put requirements on banks that had over $50 billion in assets, was changed in 2018, and those requirements were lifted. You didn't have to fulfill those requirements up to $250 billion in assets. Do you think that played a role in what happened here?
No question. No question. These banks were subject to less or Silicon Valley Bank was subject to less regulatory scrutiny than it otherwise would have been subject to, and there's a good chance that that the higher regulatory requirements would have avoided this collapse.
All right, Jonathan Macey, thank you so much for being with us.
Great pleasure. Thank you for having me.